All right, everybody, let's call the meeting to order. And kind of got a few bills today, but the first one that we have is House Bill 5, which is one we were working on Tuesday, and we left with a kind of a conceptual amendment. And I did take that amendment to the LSO, and they, in their great form, I think did a better job than I had. I had added an extra sentence and kind of broken it up, kind of like we were talking the other day, but I believe that this proposed amendment number 1 really captures what we were talking about. So for members of the public listening in, it was really kind of a tortured experience with respect to the changes to 22-113, starting on page 2 of your bill and going on to page 3, and trying to sort out what are public records, what are not public records, and keep it also determinate for future things that might be identifiers for people. So, and remember, we just kind of clunked around in here. But there is a proposed amendment, and I'd be happy to read it through. I think we finished public testimony and things, so, but I certainly, has anybody in the audience, have you seen the proposed amendment? Ms. Simmons, do we have an extra copy for Ms. Simmons or anybody else in the audience that wants one? I shared it with Secretary of State's office. And so why don't I just go through the amendment? I know it hasn't been offered, but it's the reason we've carried this bill over. So what the amendment would do, it's all on page 3. And on the first line, what it would really do is strike the words other than, and insert on line 1, except as otherwise specified in this subsection are not public records and shall be kept confidential. And then the next part of it is to go into line 3, and after the word state, strike and put a comma and say, after the word affiliations, insert and precinct and district numbers. So I think the way the whole thing would read, oh, and by the way, I went to the LSO, oh, on page 4, line 4, it goes to, yeah, page 4, line 4. I'm not tracking that one. I think that means that should be page 3, line 4, not page 4, line 4. Everybody with me? Because that's where it's the words shall be kept confidential are. Page 3, line 4. Let's make that change. I also note that in the LSO's proposed amendment, they don't capitalize the word names in the change. And I asked them about that, and they said that's just convention. Since they put a period before the word names in line 1, names will be capitalized in our convention and come through. So I think if I can do this right, the whole section would now read, and I will just start reading it. There's this long list of things. I'll start on line 20. Election records containing social security numbers, portions of social security numbers, driver's license numbers, birth dates, telephone numbers, tribal identification card numbers, email addresses, and other personally identifiable information, except as otherwise specified in this section, are not public records and shall be kept confidential. Names, gender, addresses, party affiliations, and precinct and district numbers are public records, period. And so that's what the LSO came up with, and I would, we could move the motion, but I want to see if there's reaction from people online or in the audience to that proposed amendment. Ms. Langford.
Good morning, Mr. Chairman and committee. Mary Langford, representing the county clerks of Wyoming. We've reviewed this amendment and fully agree that it is fine. Would
Okay.
be fine. Yeah.
Great.
We support it.
Anybody else? Ms. Simmons? You're good. Ms. Simmons, welcome.
Gail Simmons, Civics 307. Mr. Chairman, the only thing I'm missing is it appears to have left out the unique identifying numbers generated by the state. Did I miss that?
No, I think they are in
Oh,
there.
after state, strike and.
Yes.
Then I think it's great. Thank you.
Thank you very much. Anybody else? Anybody online? Mr. Secretary. How are you today, sir?
Good. How are you?
We're doing, great day. I think the Senate's taking tomorrow off.
Oh, yeah, I heard about that.
Makes this a great day.
Yeah, this makes it Friday. To you and Mr. Rubino, sir.
Yep, thank you, Mr. Chairman. We, after the amendment was presented, talked quite a bit with the Clerks Association through Clerk Irvin, provided them the amendment, which was then circulated to Ms. Langford, and I guess there's been a little bit of different messaging and as to where we're at on this. I think it's very important to provide some background on why the statute is constructed the way it is right now. And Mr. Rubino, I'm going to turn it over to him for a little bit, and he's really become done a lot of study on this, because the three statutory references do three different things. Mm-hmm. You know, in Romanet 29, you're looking at what is the definition of registry list that we release subject to what's in 22.2.1.13. And then 22.3.108, the third list is basically a narrative description of YO-Reg, which is what is in YO-Reg. So, Mr. Rubino, do you want to talk a little more about that?
Absolutely. So
Go ahead,
thank you.
Mr. Rubino.
Thank you, Mr. Chairman, members of the committee. Joe Rubino, I'm the policy director for the Secretary of State. Yeah, I'll go into a little bit of background on, I think, the intent behind the bill as it was written and the way that it was constructed, which, if the committee takes a different direction today, I mean, we've tracked that in. I just think it's important to note that 22.2.1.13, which deals with registry lists, but it also deals with what is and is not public record, that has other ramifications with public records requests made to our office and made to the county clerk's office, namely dealing with voter history files and absentee history files. The way that it was structured, and I think the committee may have had a little bit of discomfort with the way that it was read with that sentence, was that it broke out two different categories of personally identifiable information that was subject to public record and was confidential. And it all started with the first sentence there, page 2, line 16 of the bill, subsection D, unless otherwise specifically stated in this election code, all election records of the county clerk are public. And then it goes into what is personally identifiable information that is public record and what is personally identifiable information that is not public record and that is to be kept confidential. And so the intent behind the bill, I believe, was to really to go after the unique identifying number generated by the state, so the voter identification number, that there was a question under the language of the statute as it was then written, or as it's currently read into the statute, which is it, first of all, is it personally identifiable information, and is it public record? The way that it was originally written is that it falls into the enumerated category of personally identifiable information that is public record. And so then when we go into, and I think, part of the amendments that were made on Tuesday were to make it easier to read, I think, by breaking up that sentence, but I believe there was a reason that it was broken out into two different categories of personally identifiable information that was public record and personally identifiable information that was not public record. So that's just a little bit of background, I think, for the way that the statute read, and I think there was some thoughts on how we might clear that up and make it easier to read. But I think that once you read it a couple of times, you realize why it was written the way it was written and why there were two categories. All going back to erring on the side of transparency with the first sentence, which is, unless otherwise specified in the election code, all election records of the county clerk are made public. I will note, while we're up here, the Secretary of State's proposed amendment to House Bill 5, and I'm happy to hand that around. But on page 3, line 22, so we're discussing 22.3.108, subsection A, Romanet 10, information relating to registration status. So in context and a little bit of background, that was added in because there was also a concern that needed to also be made public. But the way that the statute read, so in 22.3.108 in its entirety, 22.3.108, it really describes our WyoReg system. And so it breaks it into two places that the official registry list shall contain at least the following information as to each registered elector. And then that's subsection A. Subsection B is the official registry list may contain the following information as to each registered elector. Subsection B, the may contain, in Romanet 3 already contains date of registration. So we've added into 22.3.108 subsection A into the shall information relating to registration status, which really is getting at the date of registration. And so I'll go ahead and pass this around now, and then I can walk
Please
you
do.
through.
Maybe we can get some help on that too. And if you have some for the audience, that'd be great. Thank you. Folks in the audience, does anybody want to take a look at this? Do we have any extra copies? Can we share it, please? Yeah, and we can share up here as well, so. Have you shared it with the clerks?
Yes.
Okay, they've got it. Okay. So your proposed amendment, you want to change page 3, line 22, strike the existing or the proposed language and put date of registration. And then I assume that it is date of registration that is the part B, Romanet 3, that you're taking away. So in essence, you're moving it from may to shall. It's kind of the way it works.
Yes, Mr. Chairman. So the way that it was, I think, added in there, and it was a committee amendment.
Right.
I think when we get into reading the text of the bill itself, maybe we don't see the larger picture of the statute. So really, this just clarifies that if we're moving it into the shall, which was the intent of that, then there would be no reason that it would be in may, because there's no other category of information that's both in the shall and the may, and that wouldn't
Yeah,
really
it makes it a little odd. So
Yeah.
I think
And
that sounds like a great catch. Let's, did you have any other things you want to say right now? Because I'd like to run it up this flagpole. So, Mr. Secretary.
Yeah,
Oh, any questions for Mr. Rubino? We good? Back to you, Mr. Secretary.
Mr. Chairman, just wrapping up here, I think the 22.2.113 section, which I agree reads a little bit clunky. There's a reason, though. There's this beautiful thing happening where they're kind of going with personally identifiable information that is not to be released And then after that other than is the personally identifiable information that is to be released. So our overall ask, and you probably see it from the amendment, is to keep the construction the way it is. Ms. Simmons' point about precinct number, that is appropriate that is in Romanet 29. And that was just, we need to add that cell to voter history. That was why Ms. Simmons didn't, it had been the convention of the office that on the voter history file, precinct number was not listed, while on our voter registry list and on the absentee history file, it was. We're going to reverse that convention and release precinct number on all three. That makes sense, and that is not personally identifiable information, and it is in Romanet 29. So what she noted from her situation, I know she sent an email that we were talking about before. I think that is a separate situation that isn't. So overall, we'd like to keep the construction the way it is and then fix that little issue that our tech division identified regarding registration status, which our understanding from the amendment over in the House meant date of registration. That's already in our may section in our description of while reg. We'd like to move it to shall. And I hope Clerk Irvin's here. The way he described it to me is that he at least agrees that we should keep the overall structure the way it is. If we go down a different route, they have I think some ideas on where you could go outside of the original amendment, but that's our overall point of view.
Great, thank you, sir. Questions for Mr. Secretary? Senator Scott.
Mr. Chairman, and maybe I'm missing something here. My reading is that we could adopt both amendments. They're not in conflict.
I don't think they're in conflict, Senator Scott. I think the Secretary prefers that we not take up the one that our LSO developed, though. Mr. Rubino.
Mr. Chairman, yeah, that's correct. And I think that was back to the, Senator Scott, that was back to the history, I think, that I laid out of why the statute read the way that it did with the personally identifiable information.
Okay. Anybody else? Should we go and see if Clerk Irwin can join us? Well, we better take Fremont County first. Let's get them both in.
Morning, Mr. Chairman and members of the committee. I just have a question, and maybe Mr. Rubino can answer this. But so I always go back and look at definitions after we're talking about this. So the definition of registry list is the list of precinct of the names, addresses, party affiliations, and precinct and district numbers of the registered electors in the county prepared by the Secretary of State or county clerks for distribution as provided in 22-113. Is that a problem at all? Or I think that, and this comes back to what Senator Barlow said the other day, is, you know, what's a list? What's a registry list? And things like that. And so I think there's what needs to be in the WIO-Reg list for us to have in our system. And then this one talks about what we're going to distribute, which already by itself, the statute then is telling me we can give out a list with driver's licenses and social security numbers, which I guess I didn't ever read it that way. So I'm just kind of throwing that out, and I don't know if they reviewed that or not, and if we're okay. Thank you.
From Ms. Freeze, do you want to address that? Mr. Secretary.
Mr. Chairman, so Ms. Freeze, again, 22-113, it starts out, those things that are listed are not a public record. And then it says other than. So that first list there are the things that are personally identifiable information that is not to be released. Social security numbers, portions of social security numbers, driver's license numbers, birth dates, telephone numbers, tribal ID numbers, email addresses, and other personally identifiable information. That's the catch-all. Then you have the other than, and that's the personally identifiable information that they've identified to be released. And that's that tension there in that statute. It's why it's constructed that way. And And once you read it a couple times, I think it gets clear what they were trying to do there. You want to take the other question?
Ms. Freeze, you want to follow up? I'll let you guys go back and forth a little.
Mr. Chairman, Senators and Secretary Gray, thank you for that. I just wanted to make sure that it wasn't going to hamstring us. As you can see, when clerks are going to have to look at several different statutes, it can be confusing. So thank you for that.
And Ms. Freeze, this is, did you hear the discussion of the proposed amendment from the LSO, as it was presented? Have you seen that amendment? And then you've heard the discussion from the Secretary of State, and I'd be
Mr.
interested.
Chairman. Yeah,
Go
Mr.
ahead.
Chairman, Senators, yes, I have seen, read, and heard all the discussion, and I'm good with that. I just wanted to make sure that we weren't missing something in the definition section. Thank you.
When you say you're good with that, are you good either way with the committee's proposal, or it's not a proposal yet? It's an LSO proposal, and then I think the Secretary of State's office would prefer that we didn't do that. So,
Okay.
anyway,
I think we could administer it. So either way, I'll let you guys fight that out. Maybe Malcolm has some more to add to that. But thank you for letting me ask that question.
well, it's not going to be a fight, Ms. Freeze. We're just
Well, I didn't mean fight it out, but you know
we're
what
all
I mean.
gentle people. No, I'm teasing. I'm just
Debate that, thank you.
okay. Thank you, Ms. Freeze. Questions for Ms. Freeze? Any questions? Mr. Irwin, welcome.
Good morning, Mr. Chairman. I appreciate the opportunity to join virtually. It's always my preference to be in person, but I appreciate the opportunity. 22-113 is it is an odd construction. The thing I don't like about the proposed amendment, and with all due respect, Mr. Chairman, I don't care that the statute would start with unless otherwise specifically stated, and then later it says except as otherwise specified. I just feel like those two start to make it say this but that and make it more confusing. And so, Mr. Chairman, I don't think 22-113 really has an issue now that registry list is further defined. Really, the genesis of this issue was that we made a reversal in releasing the voter registration number generated through WildReg and the absentee ballot status. So really, those were the two questions we needed answered. Are those public records? And I think by adding those in the registry list definition, that does just that, Mr. Chairman. And so our question has been answered through this bill. And I think 22-113, although awkward, it stands fine on its own. Now that we know that the definition of registry list includes absentee ballot status and registration dates. So, Mr. Chairman, that's just that clarification that I'd like to provide, that I think our question is answered now, and we appreciate the opportunity.
Thank you very much, Mr. Irwin. Let's see what the committee has questions. Senator Barlow.
Thank you, Mr. Chairman. So should the list that is registry list under 102, which is what we keep referring back to, the registry list that will be provided for distribution as provided.
Senator Barlow, maybe you can tighten up on that microphone.
All right.
Got that
So
drop
the
at the
registry
top.
list 29, what people have been talking about, Romanet 29, which is on line 11, for distribution as provided. Should that be the identical list that we're now talking about on top of page 3, the exceptions or the other than? Should that be identical? That's my question, because right now, even with the amendment or the non-amendment, et cetera, they are not identical. Thank you, Mr. Chairman.
Thank you, Senator. Mr. Irwin.
And Mr. Chairman, I think that would be a positive change. I am always a fan of working lazier. And so anytime that we can have a single list for distribution, and the Secretary alluded to the fact we have 3 separate lists we're providing through campaign season. And so the ability to release a single list would be, obviously for us, much simpler. And so, Mr. Chairman, I think Senator Barlow has a very valid point, which is they should be identical.
Okay, thank you, sir. Any other questions for Mr. Irwin, Clerk Irwin? Thank you very much. So I just throw this out to the clerks. You guys are being so nice, but would you prefer Mr. Irwin's way or the rest of you? Ms. Langford, you testified earlier that you're okay with the amendment, but On further reflection, where we at? You're going to go, you're pointing to Mr. Irwin? Yeah, Ms. Freese, where are you at?
Mr. Chairman, I would go also with Malcolm. That's what I was trying to say earlier is when you have three different places that says something about the same issue, then it might be hard for, especially a brand new clerk, but even a seasoned one looking at this going, okay, what is it? So I like the idea of what Malcolm mentioned, so.
Okay, back to the audience, looking in the back row, nodding heads. Where we at? Mr. Secretary, go ahead.
Senator Case, I think we would like to weigh in on that question from Senator Barlow on Romanet 29. Do you mind if Mr. Rubino?
Not at all.
Thank you.
Let's get it right.
Mr. Chairman, Senator Barlow, so you're suggesting that we parallel everything with what's in 22-113? I mean, the reason that currently that it has in 102, Romanet 29, the cross-reference to 22-113 is that you have the registry list. This is what is provided by our office upon request, and that's by statute. And then 113, that talks more generally about election records that are public record and are not. And so I think the way that it reads right now, I think that gets at that. And I don't believe that you would need to go anywhere beyond exactly what you reference in 22-113, because that just modifies the election records that are public and that are not. The registry list under Romanet 29, that is the list that's provided by our office upon request. And so you include certain fields in there, and then the way that it's working right now, I believe there's no issue with that except for what's been identified, which is the necessity and the intent of the bill, which was that there were different interpretations of what should be released, specifically with the unique identifying number, which is generated by the state. That has since been reversed by our office. And so we're absolutely on board with this. And I think codification and increased transparency with that is absolutely a positive step. But I think there's a reason that it cross-references 22-113.
Senator Scott.
Mr. Chairman, and I'm looking at the default position is if we get all tangled up in this, am I right in thinking that substantively the trouble was caused by an unfortunate legal opinion about a year or so ago, or 2 years ago, I forget which, Mr. Chairman, and that you guys have fixed that. So if the bill gets all tangled up and we can't get it passed, we're in fine shape that you guys have substantively fixed the problem that caused the bill. Is that right?
Mr. Secretary.
Mr. Chairman, I'm confident in saying the provenance of the intent of the bill has been resolved by our office. We've gone back to the convention that was in place for 2 decades almost since the office began managing the statewide registration list as provided by federal law. And I could make some arguments as to why maybe we just want to keep it the way it is, but maybe I won't do that. But I think that we've reversed what said about this debate.
Gotcha. Thank you.
In answer to your question.
Anybody else? How about, let's hear if anybody else got any heartburn about the way this is developing this morning. Ms. Simmons, you've been weighing in. How about you give us one more shot? And then we're just going to make a decision.
Gail Simmons, Civics 307, and I'm happy to say that I agree with the Secretary of State, and also the question, Mr. Chairman, that Senator Scott had, which was all of this was created by a decision made a year ago that voter identification number, that unique identifier, was confidential.
Yep.
If you were to do nothing else with this, but understanding that a statute goes beyond who the current occupant is of the Secretary of State's office. So a year ago, it was somebody else, and a different counsel, is if you wipe everything else out and simply add the unique voter identification number to the registry list that is made public, you probably do the least amount of damage.
Thank you, Ms. Simmons. Questions for Ms. Simmons? Thank you. So, Senator Landon.
Mr. Chairman, thank you. So, Ms. Simmons, I thought it was you that brought up the issue of the precinct. And if we leave the bill the way it is, going with the gentleman from the Secretary of State's office, it does not include the precinct language. Is that included somewhere else that I'm missing? I just want to make sure we don't miss something.
Ms. Simmons.
Mr. Chairman, Senator Landon, so there are, from Weil Reg, there are canned reports that already exist in which the precinct number and legislative districts and municipalities and all the other that were in there. Unfortunately, those canned reports were no longer being used. So actually the precinct number and districts for the last 7 years, excluding this past year, those were always being provided.
Okay.
So the 3 sections are, as pointed out, everything that's in the system, which is both confidential and non-confidential. The second one is the standard registry list that is made public, that is used for walking lists and parties and all that is specifically stated, here's the items, and that does include the precinct number. And then the third piece, as Mr. Rubino pointed out, is upon public information requests, which includes, for example, what I asked for, which is voter history file. Unfortunately, when they made that change a year ago, it kind of jumbled up what was going on. That standard report, going back 7 years, always did include those. It was just this last one that, for whatever reason, was not included. So that was missing. If we go back to the canned reports that we had had for the 6 years previous, we're fine. So, as long as the Secretary of State's office is stating that what they currently have agrees that those 2 numbers, the political districts, the Senate and House districts and precinct will be included regardless, then I think that's fine.
Okay. Anybody else?
I know.
Mr. Secretary.
Mr. Chairman, just to respond to that question, Senator Landon, it is listed in existing statute in Romanet 29. And if you look on Romanet 29, after the new language, it says and precinct and district numbers. And our contention is that that's the place to put it because it's not personally identifiable information. And I will say too, the one reason why you might want to do this, I forgot, is that, I won't be here forever. So, you could have someone reverse it. So.
Thank you, Mr. Secretary.
Thank you.
Anybody else? Any questions? Thank you all. I think we've had plenty of input. I don't recall if we had a motion on the bill or not. I think we did have. Debbie's nodding yes. So we have a motion on the bill. And now the question is, which course on amendments? Committee?
Mr. Chairman, I would move the proposed amendment provided by the Secretary of State, which goes into page 3, line 22.
All right. Okay, it's been moved. Discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That's carried. Are there any other motions on the bill? Are there any other motions on the bill? Not seeing any. Debbie, would you please call the roll?
Senator Barlow?
No.
Senator Boner?
Aye.
Senator Landon?
Aye.
Senator Scott? Aye. And Mr. Chairman?
Aye. The bill's passed. Thank you very much. I think that was a good job. We went down a rat hole for a while. Appreciate Mr. Rubino, especially you, and Mr. Secretary helping us out with that. Okay. That's the next bill for our consideration is House Bill 86, Disclosure of Private Cryptographic Keys. This is the last committee bill that's I think we'll get at this committee, so that's why it's got priority. Senator Rothfuss, thank you. Senator Rothfuss is distributing a draft amendment. Kelly, are we going to have anybody online on this bill? Not yet, anyway, okay. And does anybody in the audience want the draft amendment? Mr. Lindholm would like it. We're sharing, so he's got one. Anybody else in the audience need the draft amendment? Mr. Meyer does. Okay. The floor is yours, Senator.
Thank you, Mr. Chairman. Mr. Chairman, I bring House Bill 86, disclosure of private cryptographic keys. This is work from the interim from the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology. And this is a concept we've actually been working on for several years, and it relates to a concept that I know we've discussed in this committee about how cryptographic signatures and cryptographically signed transactions take place. You have what's called a public key, private key system that is the standard for blockchain transactions as well as our banking transactions. Just about everything we do relates to public key, private key transactions. Those two keys, the public and private key, are related. My public key is just what it sounds like. I make it public. That's authoritatively my key. And you can link transactions to me by knowing that public key. And any transaction that I sign with the public key, you can understand that I was the signatory of that. So that's a big part of the security. To authoritatively be able to transact, I have to have the private key. With the private key, I'm capable then of acting on behalf of the account, the identity, everything else. So I'm authoritatively able to act, not just disclose what actions have been taken, but actually to take the action. The way we established ownership of digital assets in Wyoming statute is by basically saying, if you've got the key, you've got the ownership as the first approximation. And that's the gold standard that now other states are looking to as how to determine ownership of a digital asset. Well, if I've got the private keys, I've got the ownership, I've got the control, and then with that public key, I can demonstrate it, but only through the private key can I actually sign and transact. So it's a very important distinction between the public key and the private key. One of the things we wanted to do through the Select Committee is clarify the protection of the private key from disclosure basically in any way. And that's the priority that the Select Committee comes forward with, is that the private key shall not be disclosed in any case where a public key is sufficient. That was the standard that we were bringing through the Select Committee. And I'm going to briefly walk through the bill and then talk a little bit about the amendment, where all the amendment does is bring it back to the original legislation that passed the Select Committee and reverses the House amendment. So for those that are listening online, if you don't have a copy of the amendment, it's just important to understand that it does nothing new. It just takes it back to the original introduced bill as passed the Select Committee. Mr. Chairman, as we walk through the bill, page 1 onto page 2 is the core concept, and I'm going to start from the original language that no person shall be compelled to produce a private key or make a private key known to any other person in any civil, it originally said criminal, administrative, legislative, or other proceeding in this state that relates to a digital asset, digital identity, or other interest or right to which the private key provides access. And this is the key point that we worked a long time on. What would the exception be? When could it be needed? Unless a public key is unavailable or unable to disclose the requisite information with respect to the digital asset, digital identity, or other interest right. So what does that mean? That means if the public key is sufficient to tell you what you need to know, you can't ask for the private key. And that's really important. If you have the public key, you should know everything you need to know. We couldn't come up with a scenario where that wasn't the case, but there was concern among some legal folks, you know the folks, that maybe something would come up where you indisputably needed the private key instead of the public key. 0 scenarios came to mind, but we put the language in on the off chance that we just couldn't come up with the scenario, saying that if a public key was insufficient, then you could potentially compel the private key. You see on the B provision, language that clarifies that all of the law enforcement traditional activities are still allowed. So you see this section shall not be interpreted to prohibit any lawful proceeding that compels a person to produce, sell, transfer, convey, or disclose the digital asset itself. Again, this is a key delineation. The private key is the secret. The digital asset is like any other intangible personal property. So you can compel that. The court could say, hey, you have to transfer your cryptocurrency as a result of this court decision, or you own this non-fungible token. We decide that it's fraudulent. You have to transfer that. So everything with regard to the property rights is standard law. This only is intended to affect whether or not you need to disclose the private key as opposed to the public keys. The last thing the bill does on page 3 is simply go in and explicitly provide that definition of a private key, which means a unique element of cryptographic data or any substantially similar analog which is held by a person paired with a unique publicly available element of cryptographic data, so that gets to the public key aspect of it. And C, associated with an algorithm that is necessary to carry out an encryption or decryption required to execute a transaction. We spent quite a bit of time working on this legislation to get it to the point where it would be the gold standard of the country and would achieve all of the interests of this space as we move forward, again, consistent with our other legislation. The concern we have with the amendment that was put on in the House is that it does actually the opposite. We would go from being the first state to clarify protection of a private key to being the first state that clarifies that we're not protecting the private key. That then changes it from a good bill to an actively bad bill that I would then have to oppose. It's a big difference, and it doesn't look like a big difference, but it's an incredibly big difference. So, Mr. Chairman, this takes it back through the amendment where we strike the beginning of the paragraph at the bottom of page 1, unless otherwise directed after in-camera review by the court, and then starts back with the original no person shall, and then goes on to page 2 and reinserts criminal. And I'll tell you independently the justifications for those. We discussed in-camera review extensively in the Select Committee. This was an intentional choice not to include it because, again, it's different than just knowing. It's controlling, full and complete control. The public key should provide the knowledge by disclosing the private key, even to in-camera review. There is then no assurance that somebody would not be able to fully and completely control all of the digital assets that are under that private key. That's not a responsibility I think the state even wants, realistically. You would have to achieve a great bar before it would be a wise choice to have that private key. Again, we allow for the possibility of it if for some reason that public key doesn't provide the information that's needed. But compulsion of that private key has to be another level higher.
Can we interrupt you, sir?
Absolutely.
So I'm trying to draw a comparison from an in-camera proceeding that might occur with non-digital assets. And so I think in an in-camera proceeding, the courts could explore, say, the ownership of a company, the assets of a company, on and on and on, and they could explore it to the 10th degree, but they would not have the ability to substitute their signatures or control of any of the assets. And I think what you're saying here is that if you require the disclosure of the private key, you're actually surrendering the company to the in-camera proceedings. And it's not analogous with the normal in-camera. Am I on the right track?
Mr. Chairman, you're exactly right. You're basically transferring equivalent ownership of all of the assets under that private key to the court for the in-camera review.
Okay. Keep going.
Okay. And the second point gets to a discussion that we also had on page 2, line 2, any civil, the strike of criminal. Again, this is something that concerns attorneys, and I understand that it concerns attorneys. They like to have a lower standard or a higher standard for criminal proceedings, and they like a criminal court to be able to do everything that's needed to work through a criminal case. I understand that, but in the same language on lines 5 through 8 should protect the criminal court if they find themselves requiring production of a private key as opposed to being satisfied with a public key. The concern that we had when we talked about whether to include criminal or not, if you don't have it in the list, you're implying that it's okay to compel the private key, and you're implying that the protection is intentionally not there, which again lowers us to the lowest standard in the country because we would have at least an implication that it wasn't protected. Baseline right now, honestly, we don't know. Courts haven't decided on this. Courts haven't ruled elsewhere about compulsion of a private key. And so there would at least be hope that the courts would take enough testimony, there'd be appropriate rulings, and we wouldn't have clarity in law that would imply that compulsion is a good idea. We want to take it, obviously, to the highest protection and make it clear to those that want to work in digital asset space what our expectation is. But we're very worried that by leaving out criminal, the implication there is it's okay in a criminal case to compel a private key, which again, criminal cases would be frequently related to fraud and other things along those lines. There's no question that you would end up in criminal space with regard to digital assets at some point. And the idea that you would be able to compel disclosure of the private key and associated ownership of not just the digital asset in question, this is really important, but a tremendous number potentially of other digital assets, all of the ownership would be transferred. Now, if you're wise, you don't put all your eggs in one private key basket. But still, it's normal to put a variety of digital assets under one private key. There would also be instances where potentially it's not an individual person's private key, but it might be a corporate private key where you'd be transferring ownership of all of the assets of a corporate structure that's under that private key to the court so that they could potentially consider something which, I mean, it might be a criminal case, but it might be subject of a couple $1,000s of assets, and you are effectively transferring arbitrarily, we'll say, a few $1 million of assets to the court. And then the final point I would make is we definitely trust in the court, but at the end of the day, whatever individuals in camera see that key, you'd really have no ability to know afterwards what they did with that key or if they were the instigator of a transaction. So you would immediately do your best to rekey all of those digital assets, which would potentially be at great expense. Mr. Chairman, that's the bill. I'm happy to answer any questions. I hope I made it clear the purpose for it and the need to reverse the House Standing Committee amendment, second reading amendment, which I understand was made with the best of intentions, but they were all issues that we extensively discussed during the interim and rejected intentionally.
Okay. Questions for Senator Rothfuss? Senator Barlow.
Thank you, Mr. Chairman. So the repealer is just taking the definition that's in 103 and taking it to 101, so it distributes throughout the act. Is that accurate?
That is
Thank you, Mr.
correct.
Chairman.
Yeah, absolutely, Mr. Chairman. My apologies, I didn't go over that, and I appreciate you pointing that out. Thank you.
Senator Scott? Yeah, can you regurgitate that?
We moved, Mr. Chairman, the definition of private key so that it was more broadly relevant throughout the act, so that repealer is a specific provision within, 29, oh, there we go, 103E Romanet 3, and we basically put it as 101A so that that private key definition is applicable to the entire Digital Asset Act. So it's a movement more than a repeal.
Great. Anybody else? Anybody else? Is there anybody in the audience that would like to testify on this bill? Mr. Lindholm? Where's your big hat?
Where's that?
Mr. Lindholm?
Thank you, Mr. Chairman. Tyler Lindholm, Americans for Prosperity, Wyoming chapter. On and in favor of the legislation, if amended. We would oppose the legislation if it was not amended due to the many reasons that the good minority leader brought up. But if I could make a little comparison, a comparative value, because when I've talked about this legislation in the past, it does get cumbersome when you're talking about public versus private key and digital assets and how those things work. So if I could make a comparative value to the banking world, for instance, I would say a public key would be your routing number and your account number tied together. With those two sets of numbers, you can deposit into that account. You can go into discovery in the court of law, those types of things. But you don't have control of those assets. Now, the private key description, I think, would be best understood as
Signature?
as adding your signature to that, to those numbers. And or, Mr. Chairman, if you had a debit card, your entire string of numbers, plus your private key or that private number on the back of your card, whereas all of a sudden you can expend those numbers. So that, I think, for me, that helps make sense in my own mind. And on top of that, Mr. Chairman, when it comes to the criminal aspect being removed from this legislation, I really don't understand why the House made that move. We've seen those arguments before. But in this country and the state of Wyoming, we are innocent until proven guilty. So why all of a sudden would you have to completely dump your assets, not even disclose? It's completely getting rid of assets and losing control of your own money without being proven guilty. And so that's why we are on in favor of this legislation with the amendment proposed by Senator Rothfuss.
Thank you. Questions for Mr. Lindholm? Senator Scott?
Mr. Chairman, the only scenario I can come up with where, under this bill, a private key number would need to be disclosed was where the issue related to somebody having stolen the private key. And you were trying to prove that they did, in fact, had stolen the private key. And Mr. Chairman, I think that is covered by the language in the bill that the House didn't change. Mr. Chairman?
Senator Rothfuss?
And I think that is a potential scenario, but the thing is, if I possess the private key, and let's say you also possess the private key, one of us stole it, we can both demonstrate ownership of the private key, using it, and then providing a signature with the private key. So I can demonstrate that I have the private key without giving you the private key, and it can be authoritative. And so that at least satisfies that we both own it. Disclosing it wouldn't provide any more information than me demonstrating that I have control of the private key in that instance. And then at that point, who stole it from whom is a finding of fact that you might struggle to ascertain, but you could potentially look at previous transactions or other associated information. But yes, if somebody steals a private key and you have two owners of the private key, you're going to have a finding of fact challenge. But disclosure of the key, I don't think provides any more information than just we both know the answer, and how do we look at a fact history that helps to illuminate which one is the first original owner and true owner.
I guess it comes down to pistols at 10 paces.
Always does.
Anybody else? Thank you both. Anybody else in the room wish to testify on this bill? Anybody else in the room? Not seeing anybody. Kelly, online? Nothing online? No more testimony? Committee, what's your pleasure? Motion by Barlow, Scott's moved the amendment. Discussion of the amendment. All in favor of the amendment, say aye.
Aye.
Call the roll on the bill, please.
Senator Barlow? Senator Boner? Senator Landon?
He's left a proxy of aye as amended.
Senator Scott?
Aye.
And Mr. Chairman.
Aye. Thank you very much. Thank you both. Look forward to seeing it upstairs. Representative Zawanaser, welcome. This is a topic I'm expert in, not child marriages, I probably assure you, but definitely good at marriages, or not so good at marriages. Anyway. Yeah, we should. What's the bill number? It's, House Bill 7. Representative Zawanaser.
Well, good morning, Mr. Chairman, members of Senate corporations. As I was sitting back there, Mr. Chairman, I realized this will be the first time in 16 years you and I are not on a standing committee together. So,
It's absolutely true, and not co-chairman
exactly.
of something together.
I'm back
Well, there's
on-
still tech in process. We might squeak
still
that one
make-
out.
But it's good to see you, and I'm sorry, committee, I won't be joining you in the interim, at least as on that side of the dais. Today, I'm happy to present House Bill 7, underage marriage amendments. Quickly, as you're all seasoned legislators, you know that each state actually is granted the rights to decide rules around their own marriages, and so that includes setting the minimum age for marriage. Wyoming is currently one of 8 states remaining, I believe, that do not set a minimum marriage age in statute. So you can look at our current statutes. 16 is generally the floor with exceptions from a judge. What this bill seeks to do is make generally 18 the floor, with some exceptions from either a judge or parent permission for 16 and 17-year-olds, but in no case would anyone under 16 years of age be allowed to be married. That really is the crux of the bill, Mr. Chairman. You can see there's provisions of the process having written or verbal consent from a parent for a 16 or 17-year-old. If that's not given, a judge can still grant that permission and have their county clerk order a marriage license to be given, but in no case can that happen if either party is under the age of 16. There have been, I'm assuming you've also gotten emails, as we did in the House, regarding that many states, and there's a nationwide effort underway to set the floor at 18. For a state like Wyoming, I don't believe that's appropriate. We do have instances in our laws now that allow for emancipation, for homeless minors to contract in some cases. And so we did discuss the amendment of 18 as the minimum floor, but in the House, we felt that 16 was still, had some disagreements that maybe there are some cases even below 16. I do believe 2 states allow 15 as their minimum marriage age, but this bill seeks to make it 16. Happy to discuss the bill. I know there are other people here present who can discuss, some of the social ills that this bill seeks to address and avoid, primarily underage marriage of teenage girls to older men, sex trafficking, dark areas that we're trying to prevent. And so that's why the bill has come forward. Many states in the past 5 years, out of the Me Too movement, here about 5 years ago, have started bringing similar legislation to try to increase the minimum age of marriage in their states. And so Wyoming is one of 8 states left. I would submit to you, we do not want to be the last state that allows child marriage, because we certainly don't want to attract bad actors to this state. We have had instances in the past 10 years of a 14-year-old being married, have had instances of men over 30 marrying 16-year-olds in some of our counties. And so I think we have roughly 20 on average. If you look at the last 10 years, before then it was about 40 on average from 2000 to 2015 of underage marriages, so 17-year-olds, 16-year-olds and younger. So not a rampant problem, but I do believe when I looked, we were 3rd per capita in underage marriage for our population. So happy to answer any questions, Mr. Chairman or committee.
Questions for Senator, or for Representative Zawanaser? Senator Boner.
Yeah, so those numbers you just gave us, those are all under 18, right? I was just wondering if there's any further delineation between anybody younger than 16.
Representative.
Mr. Chairman, Senator Boner, so the numbers I just gave are under minor marriages, so anyone under 18. Vital Statistics is here. We have some other people here have the numbers from last year on, a 16-year-old marrying a 32-year-old, 16-year-olds marrying 24, 25-year-olds. And so there are certainly legitimate reasons, I think we're all aware, to if there is a minor and pregnancy occurs, any number of things that perhaps a 16-year-old, 17-year-old, for a plethora of reasons, would be allowed to be married with parental consent or judge's consent. But yeah, that was to answer the question. That's just about 20 to 25 a year in Wyoming involving a minor now.
Anybody else? Representative, so if I'm looking at the digest, it looks like the only amendment that passed was to change the effective date. Is that right? That's why we have a green copy?
Mr. Chairman, that's correct. We were having a third reading active debate, and then one of our freshman legislators, kind of out of nowhere on his own volition, brought a change to make it effective immediately. And it went through without comment on that amendment whatsoever on third reading.
Okay. And then the requirement that all marriages involving a person under 16 years of age are void. So that is only extant to the existing circumstance, right? So if someone was married at 15 and now when we find out about this, they're now 17, that marriage is not void, right? Or how does that work?
Mr. Chairman, Section 2 of the bill, the act only applies to marriages starting with the effective date of this act. So
Okay.
anybody in Wyoming who is married, at 15 or younger, where their marriages are intact and valid and no concerns.
Okay. And then there's a second piece of that. No, I don't think there is. I think that captures everything. Thank you. Senator Scott.
Mr. Chairman, what happens, am I right in understanding your testimony that there are 2 states that allow 15? And what happens if somebody who was married in one of those states comes to Wyoming? Does the full faith and credit clause of the U.S. Constitution mean we have to tolerate that?
Representative.
Mr. Chairman, Senator Scott, I believe the states are Hawaii and Oklahoma or Kansas, or the other two. From my many years of dealing with marriage statutes, we do have a provision in our statutes that say we recognize all foreign marriages from other states and arguably foreign countries. And so we would recognize any marriage illegally contracted in another state if they were to move to Wyoming.
I remember some previous discussion about marriage in Wyoming that we had. Yes. Okay, anybody else for the representative? Thank you, Representative. Let's hear from the public on this. Ms. Parrish, did you want to start? We'll get to them. I promise. I guess they're hidden behind the post. Yes, there he is. Thank you. Go ahead, Ms. Parrish.
Mr. Chairman, Senators, thank you. My name is Denise Parrish, and I'm here as a representative of the Zonta Club of Cheyenne. And the Zonta Club of Cheyenne is part of Zonta International, which has a mission of making life better for women and girls around the world. And it also has a signature project of ending all child marriage below the age of 18. However, given the lack of minimum age limits in Wyoming, we are supportive of this bill, which would set a minimum age of 16. It's much better than what we have right now with no minimum age, as representatives wanted to explain to you. I also distributed through your staff a handout that you have that the 8 states are on the back that Wyoming is part of that has no minimum age. And you'll notice that most of those states for below the age of 18 have some sort of family court or guardian ad litem relative to looking at those younger marriages. I'm not suggesting that here. That would be wonderful if we had that, but I'm not suggesting that. I am in support of the bill as it's been presented. I just wanted to address perhaps a couple of things that came up in the House when this was discussed. And there was a lot of discussion about this ought to be a family decision and the government ought to be, stay out of it. But in looking at the Wyoming marriage statutes, it's listed as a contract. So the government is already in it. It's a contractual arrangement that's defined by Wyoming statute. It is the state and the municipalities issue marriage licenses, which is a government function. And so, you know, to argue that government should have no role in this, it seems like that train has left the station. And so this really is just trying to make it so that even though there's a small number of younger folks getting married in Wyoming, the statistics show nationwide that they're less likely to have as good a life as if they waited, that they're less likely to complete their education, they're more likely to live in poverty, they're more likely to have health issues. And so, and I would just conclude by, there was a young woman from Cody High School that testified at the House committee when this was heard, that was visiting the legislature that day and got up to testify and said, we recognize as teenagers, we're not ready to make these decisions. We don't have the capacity to make these decisions. It was powerful testimony. And you know, there's so many things that people can't do below the age of 18 and certainly below the age of 16. There's no reason to allow them to make a life-changing decision of marriage at that young age.
Thank you, Ms. Parrish. Questions for Ms. Parrish? Thank you very much.
Thank you.
Mr. Winnie, and then let's get vital records up to the table too, the Department of Health. Mr. Winnie.
You have Mr. Chairman, Bill Winnie, Sublette County. Late in my career in active duty in the Navy, I served as commanding officer of a large Navy ship, crew of 13 to 1,400, probably about 300 or so men and women in the 18-19 age bracket. And in my observation, they would be too young to marry. On the other hand, this nation has said if you're age 18, you can carry a rifle and participate in combat. And indeed, both men and women in Afghanistan and other places have served very well in that capacity. So 18 it is, but I support the bill under 18 because in my observation of that crew, those young men and women would not have been ready at that age. I have a son who got married at age 18. Sadly, the marriage didn't last. The military had a long-standing tradition that disappeared in the 60s, that if you were going to get married at age 25 or less, you had to get permission of your commanding officer. That disappeared in the 60s, and so no longer there, but it gives you the idea. And so I support the bill.
Thank you, Mr. Winnie. Questions for Mr. Winnie? Thank you very much. Yes, sir. I'm so sorry. I can't recall your name, but go ahead.
Mr. Chairman, Guy Bedoin, Wyoming Department of Health Vital Records.
Welcome.
Thank you, sir. To piggyback on a comment, I remember as a young enlisted soldier, people 18 years old in the company that I was in at Fort Campbell, Kentucky, wanting to get married, had to get the permission of their commander in an effort to get married. So
how'd that work
brought
out?
back some old memories.
How'd that work out?
It wasn't me, but I think they're probably okay.
Sorry about that.
Yeah. Thank you. Mr. Chairman, a couple of things with this, and I, as Representative Zwanitzer brought forward, when I testified in front of the House committee, I misspoke on one of my comments about the age that we had in Wyoming. My staff did a wonderful job of preparing the statistics for us, and I'm reading the words right in front of me, and I did not portray that or provide it to the House correctly. So under the age of 18, as Representative Zwanitzer said, in the past about 12 years, 11 years approximately, 20, the average age is 20. Of those members who were 17 and 16 years old that got married in the state of Wyoming. Last year, we did have an individual that was 32 years old that married a 16-year-old. With the change in our statutes when same-sex marriages became legal in the state, we changed the terminology. It's an applicant and a spouse. So the only place we can get sex in those statistics is if it's actually recorded in the worksheet. And sometimes people will opt not to put that into their worksheet when they request the license. So 20 is the number for the last approximately 11 years. This past year, there were 16 that were 16 and 17 years old that received a marriage license and followed through with that in the state of Wyoming. Mr. Chairman, you brought up a very interesting note, and Ms. Fries in earlier testimony today said there are a lot of different statutes that cover the things that we do in the state of Wyoming. The clerk's authority for their job is in Title 18. Title 20 covers marriages. You brought up void marriages. That's the dissolution of marriage. It doesn't say divorce in the statute, actually, but it says void. And who voids that license? Is it the clerk that does it? In the clerk statute, it doesn't say the clerk does that. It says in the statute that under Title 35 that we can have authority on those records. So I think that's something, and the reason I bring it up is that if this becomes effective upon signature, I've got a lot of work to do with the clerks in order to make sure we're all on the same sheet of music with regards to who is going to void those documents and who is going to go in to clear those records. So we will work on that. We can do all of the things that are noted in this statute, and I would stand for any questions that you might have.
Thank you for the great testimony. Anybody else? Senator Boner.
Thank you, Mr. Chairman. Still trying to get an understanding of the impact of this legislation. So you went over the numbers of people that were married at 16 and 17. How many were married 15 and younger?
Go ahead.
Mr. Chairman, Senator Boner, I don't have any record of an individual at the age of 15 this last year being married.
But there certainly has happened in the past.
Mr. Chairman, yes, it has happened in the past.
Yeah.
Right now, we just set our statistics for 16 and 17 basically to cover this. I can go back and pull those numbers at 15. Mr. Chairman, we do have two groups of, or two parties within the state. We have two Amish communities, one quite large in Crook County, the other in Johnson County, and you're getting a couple of those too, Senator Bonner, in your area as well. The Amish are oftentimes married in other states, Indiana or some other states, and they come into Wyoming, but they're holding to 18 as well right now. The majority of those that we see from birth records, they're 20 and 21 years old that are coming into the state. So I don't know that that's the response that Senator Boner was asking.
Yeah, Mr. Chairman, obviously what the bill does is it completely disallows marriage younger than 16. So I'm wondering what the other half, I mean, that's the most significant impact. I just want some basic numbers. And so that's great that it didn't happen last year, but I'm just wondering maybe over the past 10 years, how prevalent this is. And so I'm fine with the bill as is, just to be clear. I'm just wondering what the impact is. That's obviously a pretty big part of the impact.
Can you speculate about past 10 years under 16?
Mr. Chairman, Senator Boner, I would say probably 3 or 4 that have been married, and there's probably even been a 14-year-old in there. What I will do is I'll go back and we'll run those numbers and I'll send them to your email. And I know as this goes through, you'll still have an opportunity to talk about it on the floor. And so I'll make sure you have those numbers if you want them for discussion.
Yeah, and just a little bit of a follow-up. You mentioned that you don't have sex. Sometimes they don't fill out the sex and it's not required. But they do fill out age in the marriage documents, right? That's a required field.
Mr. Chairman, yes, and the clerks do a wonderful job of being able to ascertain. So they request documentation from the parties or those witness statements if they're minors. There are some times, though, that people may present false information.
Right.
And in those instances, at the last Clerks Association meeting, we talked about forming a working group to clarify some of these issues with marriages. And one of those was a checklist, basically. So when you go in and if you are applying for a license, if there's something on that checklist that you're not able to provide, a birth certificate as an example, or a divorce document, that the clerk would send you away until you bring those documents back. That would help us with the enforcement. And we can do that in rule and just with the simple checklist.
Senator Barlow.
Thank you, Mr. Chairman. I think the one question is answered, but the second question is the voidable issue that you brought up. That's not addressed in this bill. That's just another item that needs to be worked through, and you're going to work through that on an administrative basis. Is that accurate? Thank you, Mr. Chairman.
Thank you. Go ahead.
Mr. Chairman, Senator Barlow, yes, those we have the authority to promulgate rules with regards to marriages and void marriages. We're going to have to add and be more specific. The clerks, some clerks use a different system. So if I may just give you a quick scenario.
Sure, but we are tight on time now. We have one more bill that we have to do.
Okay. If you go in and provide yourself or you request a license, the license is issued from a system. Some clerks use a different system. If the license is solemnized and then we find out that the party, that it needs to be void, the clerks are the only ones the clerks that use this Tyler system are the only ones that have that license. It hasn't been exported to us yet. So we would have to go back and forth in order to figure out where that license is and then who has the authority to void that. And I think we can do that in rule. Notwithstanding what's in this bill today, we can still work through that.
Excellent. Anybody else? Thank you so much, sir. Anybody else wish to testify on this bill? Anybody else, Ms. Muir? I'm sorry, but we are trying to get to another bill today, so, but please.
Thank you,
You're welcome.
Chairman. I'm Tara Muir, Public Policy Director with the Wyoming Coalition Against Domestic Violence and Sexual Assault. We do support the bill. We definitely support the 16 and 17-year-old exceptions. We are all about empowering victims that come through our programs, and having that caveat for 16 and 17 is important. But we do see these young people in our programs, and we know that there's greater vulnerability to sexual assault and domestic violence. It's another issue, and when this issue really hit our country with headlines that child brides were, let me see what the child brides call on the U.S. states to end legal rape. And under sexual assault, we have statutes that this marriage could be also charged as a crime.
Mhm.
And that's something I think we need to look at in the future. I'm happy to take questions. Keep it brief.
And then the law you refer to is more than 4 years, a minor and more than 4 years difference in the age of the perpetrator and the victim, right?
There's that one, and then there's some that are very specific that say if this happens to someone at 16, if this happens to someone at 17, persons of authority, those kinds of issues.
Got it. Thank you. Any questions for Ms. Muir? Thank you so much. Anybody else in this room? Anybody else online? Let's let the people online. Mr. Lang? Mr. Lang? Can you tell if he's getting in? Mr. Lang?
Okay, I'm unmuted. I'm not sure if I can be seen yet. Let me quickly turn on my video. If I can.
Mr. Lang, go ahead. We hear you, but we don't see you.
Okay, well, I'll speak without the video. Thank you for allowing me, Mr. Chairman. I'm here to speak against the bill. What I haven't heard is there are a lot of times people come to me as a clergyman and ask why in the world should the state be involved in marriage at all? And my answer is because every individual has been endowed by their creator with inalienable rights. And in the case of marriage, we have the rights of three different entities involved. One of them is the right of the child conceived in marriage to be raised by his father and mother. Another one is the right of a young person approaching marriage to be able to consent to a marriage. And the other one is the right of the parents raising a young person and bringing them to marriage, and their right to guide them into the marriage process. And this bill is very much concerned with the right of the child to consent. And for that reason, I applaud it. But I think it gives short shrift to the right of that same child to consent on the other side. So the fact of the matter is that marriage is in place. The reason that the state is involved in marriage at all is to secure the rights of the child which is conceived in marriage, because he has a chance to, or has a right to be raised by father and mother. So what I'm troubled by is the total taking away of the right of somebody who is, say, 15-year-old and pregnant to apply to the court and to plead their case before the court and be married and raise the child. I have people in my congregation who were married at the age of 15 and now are celebrating their 50th anniversary. So I understand that there are risks with young marriages, but I also understand that those risks can be mitigated and can be dealt with properly by the parental consent, especially when it is parental consent under the eyes of the court. And so that's the part of this bill that troubles me, is taking away the court oversight under 16 in the case where somebody's mature enough, obviously, to have a child. That child needs a mother and father. So I stand for questions, try to keep it brief.
And thank you, Mr. Lang. By way of introduction, where are you calling from? And tell us.
Oh, I'm sorry.
You're obviously a priest. I can see that. So go ahead.
Yes, my name is Jonathan Lang. I am calling from Evanston, Wyoming, and I'm a leader of the Wyoming Pastors Network, but I'm speaking really in a private capacity here.
All right. Thank you very much. Any questions for Pastor Lang? Any questions for Pastor Lang? Thank you, Pastor Lang. Thank you.
Thank you, Mr. Chairman.
Is there anybody else online, Kelly? Is there anybody else in the room? Committee, you've heard the testimony. What is your pleasure? Motion by Barlow, discussion? Any discussion? Any proposed amendments? Debbie, would you please call the roll?
Senator Barlow? Aye. Senator Boner?
Aye.
Senator Landon?
I don't have a vote for him. Well, let's leave it open for him. Senator Scott? I'm sorry, go back to you, Debbie.
Senator Scott? Aye. And Mr. Chairman?
Aye. So it's going to pass for sure. We're going to leave it open for Senator Landon. The next bill for our consideration is Representative Harrelson. It's your bill. If you could come forward. It's a white bill, right? Is that right? And it's House Bill 103.
Thank you, Mr. Chairman and committee. Thank you for giving me the opportunity today to come before you guys. And we're going to take another whack at a bill that we just saw a little while ago. So I believe that you guys saw Senate File 141 a couple weeks ago with Senator Beitman. This is a mirror bill that I ran on the House side. It's House Bill 103, and it is its title is Political Party Affiliation Declaration and Changes. It's elimination of crossover voting. So I believe I'm not going to, you guys have seen the bill. You guys have already discussed the bill. I don't believe we probably need to have a huge conversation on it. It came out of our body unamended. The bulk of the bill and kind of the meat of the bill is going to be found on page 2, line 20 through page 3, line 4. And that just describes as a primary election will not, basically someone will not be able to change party affiliation after the May date filed, and that's in 22/5/209 and 14 days before a general election. So it came through our corporation side onto the floor and passed with a 51-9 out of the House, and it comes before you today. And with that, I stand for questions.
Thank you. And Representative, it's an identical bill, you say.
Identical.
I didn't recognize it as being identical to the bill.
It is not. It should have
Senator
been.
Boner.
I was told it was, but
Yeah, hold on.
I'll let you know, and then let's look more at this. If it wasn't identical, let's look more at it then, if
Okay.
you guys want to. And if
But
you,
we'll hear from the committee. Questions for the representative? Senator Scott?
I didn't quite hear what you said. The acoustics are bad here. It is or it is not identical?
well, I was under the impression it
Mr.
was.
Representative.
Sorry, Mr. Chairman, Senator Scott, I was under the impression that it was. So, but what this bill does is it is a crossover elimination bill that sets the date as, it's, the easiest way to say would be May 15th or round about their first day of application for unelected position, and then 14 days before a general. So this would eliminate day of, and as well as that. Some of the questions that were brought to us on the House side that we were able to get kind of answers for is what happens if someone moves from out of state in or in state out? How does that work? Does that lock them out of being able to register? This does not, because they will have that ability to be deregistered out of the state they move out of and into the state when they come into the state. The other is Motor Voter Act of 93. This does not limit anyone from being able to register to vote. This just holds back their ability to change parties of affiliation. So we had the clerks state that this does not come in contact or breach Motor Voter Guide or Motor Voter Act. So those were some of the things that we had discussions on and that were answered as it came through our side.
Thank you. Senator Scott, did you follow up?
Yeah, Mr. Chairman, so this bill would, I've got, part of my district has a fair amount of people in and out all the time with oil business, amongst other things. And when they come in, they often register and don't declare a party affiliation because they haven't figured out what the parties really mean in this state as well. And then they'd be shown as unaffiliated and they would be unable to vote in the primary then. Is that correct? And unless they change that before the start of this May date.
Representative.
Thank you very much, Mr. Chairman, Senator Scott. So if they were to register unaffiliated prior to that May 15th, that locks them in as of that May 15th into what they registered into. Now, if they came in after the May 15th, they could register into whatever party they choose or unaffiliated. Absolutely.
Okay. Down here, Senator Boner, did you wish to add anything about any of you guys? So, Representative, I'm thinking a little bit about federal elections.
Correct.
So, and I realize other states have restrictions on crossover voting, but how does it work with federal elections? So it seems to me that we may have some power to restrict people from voting in state elections that may not be transferable, say, to the issue of a federal election, say a primary election where there are contested congressional candidates. And so someone appears, maybe they're an independent and they wish to register now as a particular party to participate in a primary election. How would that work? Would they be restricted from declaring a party if they had been a strong independent for years in Wyoming? Go ahead.
Mr. Chairman, so the concept here is that I think we got two questions. First question is, on a federal election, there's no, from what we've heard from the testimony and what we've heard as we've done research on this, that there isn't a breach of any legality. That's that Motor Voter Act of 93. So that's not a breach because we're not holding back someone's ability to register on the day of election for an election or for the primary or the general. But what this does do is this would hold people into the party of declaration prior to that May 15th date or prior to 14 from a general. So what this eliminates is in this last federal election where there was a letter sent out giving people instruction on how to change affiliation to be able to vote in the Republican primary, this would in essence eliminate that ability or close that loophole.
So help me again. An independent voter wishes to participate in the primary after the period of restriction in this bill. Would they be able to declare?
Mr. Chairman, no, they would not. Because as long as if they were registered independent prior to that May 15th or 14th or 13th or whatever day that is, depending on which year it is, if they were declared independent prior to that date, they would hold that independent status or affiliation through the primary at that point. Now, they could change after voting to be something different for the general, obviously, and show something different, but obviously our general ballot is the same ballot no matter what your affiliation is.
Okay, and then if anybody else wants to jump in, please let me know. If I'm a voter and I wish to shed my party registration and become independent, is that permitted?
Mr. Chairman.
During that same time period?
So in that 4-month period or 3.5-month period, you're locked into what you started, what you came into, you're locked into. This is kind of a prohibition on changing party affiliation during that May 15th through August primary.
And supposing I've never voted before, I've not declared, I'm not a registered voter, can I register and declare a party?
Mr. Chairman, absolutely. If you've never registered to vote or you're not currently registered to vote, if they've eliminated you at any time during that period of time, you can register and declare party, whatever party you choose.
And then Representative, as I look at the First Amendment of the US Constitution, seems to protect the ability of people to assemble and exhibit free speech. One form of assembly is to associate in a political party. It seems that the converse of that would be to be able to unassociate. If you no longer wish to carry the banner of the party, the First Amendment of the US Constitution would seem to me to suggest that you should be able to shed your registration, shed your association. Would you agree with that?
Mr. Chairman, so I believe that obviously the First Amendment is a vital part of who we are and came into breach over the last 3 years more than probably ever in the history of America. But I believe this is and this is my personal opinion, that would not apply in this situation. You can choose your party affiliation going in, and you can hold that party affiliation through the primary. Because I believe that what we're having is a manipulation in sorts of elections because of this.
All right, thank you. Senator Boner?
So following up on that question, if you're going to disassociate with the party, wouldn't the simplest way of doing that simply be not to vote in the primary? I mean, if you're going to be independent?
Representative Haraldson.
Thank you, Mr. Chairman. Senator Boner, I guess I'm a little bit confused on the question. Would you mind clarifying that?
It's more of a statement in counter to the previous question, but that's.
Go ahead, say it again.
I think the idea that you would somehow be your First Amendment right to associate, or in this case, disassociate, would somehow be infringed by the bill. It doesn't carry much water with me because frankly, I mean, all you have to do is not vote in the primary. If you're going to dissociate yourself from a particular party, you can always vote in the general election, obviously, but wouldn't you agree, Representative?
Representative.
Thank you, Mr. Chairman. I would agree with that. And I believe that one of the issues that I see is the primary election process was an election process placed so that these individual parties could move forward their candidate. And then into the general election for the purpose of that election process. And I believe that as we saw, and I would assume there'll be someone that'll come up and say the stats of the numbers of people that actually did switch. This was a small issue for a long time, maybe a handful here or there, but in the last election cycle, we got to see a bit of a landslide in this area.
All right. Any other questions? Thank you very much.
Thank you very much, Mr. Chairman.
Who else would like to testify on this bill? Who else? Secretary of State's office, welcome. You guys are getting a workout in this committee.
Yep.
Thank you for your patience.
Yeah.
To you, Mr. Secretary.
Thank you, Mr. Chairman. Today, I stand in support and ask that you vote in favor of House Bill 103, which will curb the process of crossover voting in Wyoming. As we have seen over the past several election cycles, crossover voting has undermined the sanctity of Wyoming's primary process by allowing voters to disingenuously participate in primary elections in parties for which they do not belong. Allowing people to change their party affiliation up to the day of the primary election and then change back dilutes our primary system, creates incentives for individuals who do not share a party's values to nonetheless prevent voters of that party from electing a candidate that represents the party's platform by crossing over for a day and then crossing back. By contrast, fixing this issue allows members of each party to pick a candidate that represents the voters of that party, disincentivizing these tactics by requiring voters to affiliate before election season even starts. Thus, it allows both parties to put their best candidate forward, the candidate that most closely reflects the constituents within that party, benefiting the election process and the state as a whole. For this reason, I stand in full support of House Bill 103, which prevents electors from switching parties after the first day on which an application for nomination may be filed or 96 days before the primary election. This deadline, which is approximately 3 months before the primary, prevents voters from gaming the system by holding them to commit to a party before candidates formally declare. Republican and Democrat states alike have wrestled with this issue, and many states' solution has been to pass bills similar to House Bill 103. You have New York, which has a 4-month deadline before a primary election. Delaware has a 4-month deadline. Kentucky has a 5-month deadline. All these states have survived constitutional scrutiny. So I really respectfully push back on that argument. The other argument that I do think we're going to hear, obviously going first is a little bit of a disadvantage, is that this somehow puts in jeopardy our motor voter exemption. And the motor voter exemption is clearly about being able to register on the day of the election, not being able to switch, but being able to do a new registration. This does not affect that. You can register, have a new registration, and the way this reads, even if you're kicked off the rolls because you didn't vote, you can have a new registration. It just doesn't allow you to cancel your registration because that would be a loophole that would then allow somebody to cancel and move into the other party. Second, these bills accomplish what other attempts at ending crossover voting do not, and we've seen a number of different bills that don't close that loophole, and I think that's important. Finally, I will say that running for Secretary of State, I traveled this state quite a bit in a 3-month period, and this is the number one issue I heard about on the campaign trail related to our elections. It is a voter confidence issue related to our primary election process. I really ask you, if you have some objections about the date or some of the nuances, to maybe address them with an amendment, and let's get a bill to the floor related to crossover voting.
Thank you, sir. Questions for the Secretary? Any questions for the Secretary's office? Thank you, sir. Thank you both very much. Ms. Parrish?
Mr. Chairman, Senators, I had no intention of
You're
weighing in
persuaded.
on
The earth
this.
moved, yeah.
Weighing in on this. But as a long time unaffiliated voter in this state, I just have to say that given that we are becoming a one-party state, headed towards becoming a one-party state, that not being able to have any say as to those who will represent me as a Wyoming citizen, even an unaffiliated party Wyoming citizen, is a difficult choice every year that I have to make remaining unaffiliated, because I will be affected by the outcome of that primary. And as we saw this last year, the primary was the election for many of the offices. And so And so I'm not a fan of this bill. Representing myself, I still have my Zana tag on, I'm sorry, but representing myself and as a long-term unaffiliated voter, I prefer the existing system because it does allow me to at least have some say in who will ultimately represent me.
Thank you, Ms. Parrish.
Thank you.
Question for Ms. Parrish? So I think your argument is that the existing system produces a better outcome in the end, a more democratic system, whereas a restricted primary situation could yield outcomes that aren't as democratic statewide, although they would satisfy the needs of one party or another. Is that your point?
Yes, Mr. Chairman.
Thank you. Thank you very much. Questions for Ms. Parrish? Thank you, Ms. Parrish. Who else would like to address committee? Ms. Langford. If anybody else wants to come forward, you can stack them up. We've got 20 minutes left till we have to be on the floor. We will have a hard stop at 10 till, take a vote, and then we'll go forward. So we have 10 minutes left. Go ahead.
Mr. Chairman, Committee, I'm Mary Langford, and I have the honor of representing the County Clerks Association. My purpose today is to focus on the administration of Wyoming elections, and particularly the change in party affiliation. The clerks have had the opportunity to review this proposed legislation and would be able to administer it. We also feel that it has no effect on motor voter. Motor voter, as it's been stated a couple times before, is registration. A couple of concerns, though, that we do have is the fact that there will be a need for voter education. This will be a pretty drastic change for election, the way it's been conducted for a number of years, that folks that need to know that they'll need to change their party ahead of filing for candidates. So there will be some confusion because those changes will happen in May as opposed to in August when they've been used to doing that before. Disenfranchised voters, there's been a little talk of that. In the United States, there's about 39% of the voters nationwide are unaffiliated or independent. In Wyoming, as of February of 22, so a year ago, that was 14%. And as of January this year, it's 11%. And the clerks really have no position on this. As I said, we're able to administer it however it comes. And I'm happy to stand for any questions.
Thank you very much. Questions for Ms. Langford of the clerks? Not seeing any. Thank you, Ms. Langford. Ms. Lowe.
Good morning, Mr. Chairman and esteemed committee members. My name is Jen Lowe. I am the Executive Director at the Equality State Policy Center. Wyoming's elections are safe and secure. There have been no significant challenges to the integrity of the state's elections. 103 does not eliminate crossover voting. It simply changes the timeline from when folks can change their party registration to the date before they know who the candidates are. We are asking people to make a decision without all of the information available to them. Let me point out that primary elections were originally created at the turn of the century, of the 20th century, to get elections out of dark rooms and give power back to the people. That has developed over time to concentrate power with the parties once again. But remember, where those primary elections originally came in was to make voting more equitable and to increase franchisement for voters. I'd also like to point out that the last primary election, which so many folks seem to be referring to, where crossover voting did occur, the primary candidate still won by 37 points. So even with all of the crossover voting that occurred, it was a landslide election by all accounts. I know that we have heard that it won't be a violation of the National Voter Registration Act, also known as the Motor Voter Act. I would look into that very closely because losing our exemption from the National Voter Registration Act will be very expensive to the state. My concern is that by preventing folks from canceling their registration during that period, that you are in fact violating their free speech, and by preventing them from re-registering on the day of, you are also challenging their franchise. Also would like to point out, during the debate on the floor last week, it was pointed out that a current citizen-led ballot initiative is in the works. It is currently listed on the Secretary of State's website to collect signatures through May 24. I would suggest that perhaps we let this ballot initiative work its way through the process. As you know, in Wyoming state statute, the ballot initiative process will require that it comes back to the legislature before it goes to a vote of the people. So even if you decide not to push forward this today, let the ballot initiative work its way through, you would still have an opportunity to review this legislation before it goes to the ballot. With that, I'll stand for any questions.
Thank you, Ms. Lowe. Questions for Ms. Lowe? Thank you. Let's go to Ms. Herman.
Thank you, Mr. Chairman, Committee. Marguerite Herman for the League of Women Voters. And you've heard from me before on this, so I'll be brief and to the point. As I've said before, the League encourages people to be informed and vote. And this is just a form of legislation that says don't bother to be informed, go ahead and vote based on a letter after a name that may or may not indicate the way a person, way a candidate will represent you in office or run the government. Number one, the League thinks that any kind of restrictions on voting should have a concomitant benefit, make it more secure, more free, more fair. There is no benefit to the voter from this restriction. It is a form of party discipline, which I understand, that why a party might want that. I would argue that it's not a function of the state government to perform that function. It should not be in statute. That can be achieved with a caucus or some other means. There has been evidence, and what you've heard, and you'll probably hear again, that in fact, even in the season where we'll say that the crossover was unprecedented high, it did not determine the outcome of the election. So it doesn't undermine it doesn't have an untoward effect on the outcome of the primary. So that's kind of a false premise. It's a false premise that all R's and D's are in lockstep with their party, and that that's all you need to know to vote responsibly. And as has been stated before, a voter wants to vote for the individual who will best represent, serve them, will run government well. And within those parties, you can't assume anything. We have a wide range, and I'm glad to say it, of political
Can you get
beliefs
to a
within
closer?
party. I'm sorry. So I would have to say it's important to know the individual. Okay. And what other states do, I would say, is not relevant to this discussion. We are proud of our Wyoming ways of doing things, and I would say the current status is serving voters the best possible. To change it will not add anything to the process, at least as far as the voters are concerned. So I would suggest that, as Ms. Lowe said, let's let the other process play out if you want to, but this is
Let's
not.
wrap it up, please. Thank you. Questions for Ms. Herman? Thank you very much. Ms. Simmons.
Gail Simmons, Civics 307. This is a mirror bill, and therefore you are not going to hear anything today that is different than you heard either last week or the week before. Nothing has changed. So I'll just summarize. First of all, this is all out of the distinction between a major party and a minor party, which I would encourage the joint corporations to take a look at that. So the way we currently have primary parties is based on the distinction of a major party versus minor party. The 21,000 individuals who changed both in and out of all of the parties, 17,000 of them were permanently changed, less than 4,000 changed back. In comparison, 30% of registered Republicans did not vote. That's 60,000. So we're changing a bill where 17,000 people permanently changed, and yet we do nothing about the 60,000 who do not vote at all.
Get close to wrapping it up.
Yep. So this would be a permanent change in affiliation. If you want to remove incentives, take a look at major versus minor and review the primary process. It is totally inappropriate to keep people from unregistering. If that is something you want to do, it should be based on not changing affiliation upon re-registering. I urge you to not pass this as you did the previous, and look at Title 22 in the interim.
Thank you. Questions for Ms. Simmons? Thank you. Yes, sir. You're next.
Okay. Good morning, Mr. Chairman, members of the committee. I'm Mark Moody of Laramie County. I am just a regular citizen here and also a committee member for Precinct 37. I support the bill 100%. I urge an aye vote. I would say the largest impact crossover voting has on our precinct races. Precinct races not been brought up. That's the biggest impact we've had. So we did have non-Republicans voting in our precinct elections, and it changed the outcomes. They were very close here in Laramie County. So That's the impact that no one's talking about. So that's why I urge an aye vote, and I'll be happy to take questions.
Thank you, Mr. Moody. Questions for Mr. Moody? Senator Boner? Anybody else in the room? Anybody else online, Kelly? Let him in. Mr. Illaway? Let them both in.
Thank you, Mr. Chairman. Pete Illaway, citizen, and I just want to say that I'm against this particular piece of legislation, having to change your registration before the last day that somebody can vote or that somebody decides to file is wrong. You should be able to know who you're gonna at least support. And when I ran several years ago, one person that I ran against only filed the very last day, which means that I would have had to change my registration before he did, and maybe I didn't want to support him. So I think this is a wrong way to do it. It's worked well for eons here in Wyoming. Let's not change. And I better shut up.
Thank you. Questions for Mr. Illaway? Thank you. Let's go online. How about the first lady in the purple sweater, Ms. I think you're muted. Can you talk to us, ma'am? We're in a big hurry.
Good morning. Thank you, Mr. Chairman and panel. I will be real quick. I would think that this bill should be a no-brainer for this particular committee. Everyone on this committee is a registered Republican, and they understand through campaigning that this is a top issue for all of your voting constituents, at least the Republican voting constituents. I also would strongly urge you to remember that this bill would restrict, not stop, crossover voting. And I would advise that those Democrats who are Democrats or unaffiliates who do not believe in the Republican Party, instead of unethically influencing our party, that they maybe encourage or try harder to get better candidates that they would be able to really support and get behind. If only the Republican Party is putting up candidates that they want to choose, then that seems to be their problem. And that's all.
Can you wrap it up, ma'am?
Thank you.
Thank you, ma'am. Questions for the lady? And it's Ms. Aguilar, is that right? Thank you. Yes, and then one more online, we're done. Who's next online? Let's hear from her. Ms. Pearson?
Hello, Mr. Chairman. Can you hear me?
Yes, we can. It's got to be quick. I'm very sorry about that.
It's okay. Hello, Mr. Chairman and members of the committee. My name is Laura Pearson. I'm a sixth generation sheep rancher in Southwest Wyoming. I am 100% in support of this bill. We need to curb crossover voting. I want you to know that I personally know 3 people who laughingly said to me they were a Republican for a day. These activities, in my opinion, disenfranchise the vote and affect down ballot elections as well. There was testimony that even with the crossover voting, the other congressional candidates still won. But I feel as though the down ballots are affected.
Thank you, Ms.
Thank you
Pearson.
for allowing me to testify.
We really appreciate it. Any questions? Thank you. It's closed. Committee, what's your pleasure? Senator Boner. Motion by Boner. Any amendments?
Mr. Chairman.
Go ahead.
Page 3, lines 2, 3, and 4. Basically, what I'm going to try and do here is change the restricted time period from before the filing period starts to be the day before the voting starts. And so it'll shorten the time frame significantly under current statute to 45 days before the primary instead of in the middle of May. So what I'm proposing is on page 3, line 2, strike the word on, strike on page 3 up until the word under, and in its place insert of absentee voting, and then on page 4, line 4, delete statutory reference 22-5-209 and insert 22-9-107. That is the statutory reference for the early voting period.
Okay, so what is the effect of your amendment, Senator?
It would prohibit crossover voting during the time voting is actively occurring, instead of at the beginning of the filing period as it is now. So that's the effect.
Thank you. And the clerks agree it has that impact? Do you agree that that's what it does? Yeah, okay. Discussion. Senator Barlow.
Thank you, Mr. Chairman. So there's also another bill in motion in this legislature right now that would alter that. And I think it's Senator Boner's bill potentially. So I'd like to know if that bill passes, now what day were we talking about? Thank you, Mr. Chairman.
Senator Boner.
Yes, Mr. Chairman. So yeah, the amendment is written to reflect whatever's in that statute. If the bill passes, it would be 45 days for folks who are covered under the Absentee Uniform Service Voter Act and 28 days for everybody else.
Gotcha. Understand, everybody? Any more discussion? All those in favor of the amendment signify by saying aye.
Aye.
Aye. Any opposed? The amendment's carried. Back on the bill? Anything else on the bill? Call the roll on the bill, please.
Senator Barlow.
No.
Senator Boner.
Aye.
Senator Landon.
We'll keep it open for Landon. He's heard the other bill, so.
Senator Scott.
No.
Mr. Chairman.
No. Looks like the bill's failed. We are keeping it open for Senator Landon. We're adjourned. We'll come up with an agenda for Tuesday. Thank you very much.
This is easy.